I'm Bill Auten of Auten Claims Management.
I'm Chantal Roberts of CMR Consulting, and welcome to the Art of Adjusting podcast.
Today, we're going to talk about life as an insurance adjuster from the perspective of property, auto, liability, or workers' compensation adjusters. Our goal is to bring interesting topics in the world of claims adjusting to people who are working as an adjuster now and to people who are considering a career as a claims adjuster. Good morning, Chantal. How are you doing today?
Doing well, thanks. How are you?
Great. In today's episode, I hear we're going to be talking about contracts. Woo!
Woo! I mean, it's almost as exciting as policy dates.
Yeah. Which, that episode actually turned out way better than I thought. We talked a lot longer than I thought we would about that topic. It's amazing how
Right?
when you get into the details, this stuff is actually kind of interesting. So,
Yeah, it is. And it's, I think, amazing how impactful insurance is on all facets of our life.
yeah.
It really does touch everything. And contracts, it's going to sound boring, but it is actually always very important for an adjuster to understand what they are dealing with, because I don't think that the insured understands what they are dealing with.
Yeah, contracts are important to insurance because insurance itself is formed with a contract,
Absolutely.
and then other contracts that you have in life uh, tend to have a bearing on the insurance contract itself. So, yeah, there's a lot to talk about on the topic of contracts.
Yes,
So, um, I believe you had questions for me for this episode. Is that correct? Is
I
that how
do.
we're going to do this?
I do. I have a couple of questions for you, but I thought again, what we would do is before we got into those is
Yeah,
talk about what a contract is,
yeah,
a little bit about the insurance policy itself, because again, I don't think a lot of lay people, consumers, understand that their insurance policy is a contract. And so if you, as the insured, breach or violate a rule or a requirement or something to that effect, which we'll talk about a little later, that, you know, does mean that the adjuster can, or the carrier can, deny that claim. So because it's a contract, you signed it. So the contract is between the policy holder and the carrier. uh, Barry Zama, who we've had on before and we've talked about previously, I just finished showing a little clip that he gave of what an adjuster is. And he says the very fascinating thing is, if you think about it, an adjuster is never mentioned in the insurance policy contract.
that's
But
right.
carriers kind of invented the position because it is the insured's obligation to present the claim to the carrier. But lay people, consumers, are not sophisticated and they don't know how to do that. And so the adjuster's job is to help that consumer present their claim. Now, that's one of the reasons why I'm so passionate about this, because I want all the adjusters to learn that they're really here as a helpmate. So look for coverage first, is that rule.
Yeah. They and the word you use are sophisticated. That is used a lot in this kind of discussion about the relationship between insurance carriers and their customers. And it's not a derogatory term. It may sound that way. What it means is that they're not sophisticated within the language and parlance of the insurance contract and the laws and rules around the insurance contract. They may be very sophisticated when it comes to the foods they eat and the shows that they watch and the books they read. Um, but when we say sophisticated, we just mean that they're not insurance nerds like us.
Like us. Yeah, no, very, very good point. Yeah, I'm not being derogatory at all. It
Yeah,
just means that they are not familiar with the insurance rules. If I were to talk to an IT tech person or whatever, I would be considered to be unsophisticated
sure.
because I don't know anything about, IT. So there are four requirements that a contract needs to be considered to be valid. And I always use the acronym CLAC, which is C for consideration, L for legal purpose, A for acceptance and offer, and C for the capacity to enter into the agreement. And the joke that I always say is that you can never have an agreement or a contract with an insurance adjuster because obviously we don't have the mental capabilities because we're adjusters and we're just crazy because we like this stuff. So obviously we don't have the mental capabilities to be be entering into a contract.
Yeah, and that capacity part is a little confounding because what policyholder actually fully understands their policy? And yet the insurance company enters into those agreements with policyholders every day. And we've talked before that that's a contract of adhesion, meaning the insurance company drafted it, presented it, and the policyholder has to either accept it or decline it. But an average person actually have the capacity to understand an insurance policy? I would argue that they do. They probably don't read it,
Right.
so they don't have the capacity to understand it just when they make the purchase. In most cases, usually they read it. If they do ever read it, it's usually after something bad happened and they're trying to find out whether it's covered on their own. So
Absolutely.
um,
Which leads to another good point, is how to read a policy. I have heard that there are 5 or 6 parts. I, again, just boil it down to 5 parts with an acronym called DICED. And DICE is like the declaration page, and that's your who, what, when, where, and why. It's usually on your front sheet. And your insuring agreements, there are, and a lot of adjusters and insureds themselves do not understand that in any kind of given policy, you can have 2 or 3 different insuring agreements depending on what section you are looking at. So that is something very, very important to just go to the very first insuring agreement and go, aha, there is the thing that says that you have to pay for all physical damage. Well, that is for the, structure over here, not the structure over there kind of deal.
right.
Conditions. This is where, if you do this, I'll do that. You have to pay the premiums for there to be a policy. You have to report the claim on time, which goes back to our last podcast where we were talking about the policy periods and things. You have exclusions and endorsements, and then you have definitions, which are, of course, extremely important. And then I always caution when I was talking to my adjusters, I always cautioned my adjusters, don't just look in the definition section because sometimes the excuse me, don't look just in the exclusions and endorsement section because sometimes the exclusions and the endorsements can be found in the definitions. So, I mean, that's the reason why you have to read the entire policy.
You do. And you do because there are conditions that apply to each separate coverage. There are exclusions that apply to the building coverage. There's exclusions that apply to the liability coverage. There's actually a separate set for the medical payments also. And you can't assume that one is going to apply to all of those sections. So, and you may not even realize there is another section if you don't read the whole policy. So,
Exactly.
and then once you're done reading a specific form, you've got to go back to the declarations page and look at the other forms that are attached, the other endorsements that might be on there that might change some of the language that you have in the underlying form. A lot of those add-on endorsements will say, they'll actually quote a part of the policy and they'll say, this part right here is changed. And now it says this. And
Exactly.
if you don't look at those, you may wind up, as an adjuster, you might wind up declining coverage where you actually have it, which is a no-no. You shouldn't do that. Or you might be giving coverage where you shouldn't. There are a lot of add-on endorsements that take away coverage. A lot of the carriers I work for insure like landscape contractors. they don't want those landscape contractors conducting roofing operations. So they'll put a roofing exclusion on those policies. So if your lawnmower guy falls off a roof because he's fixing somebody's roof,
Uh,
and you assume that there's coverage there, there probably isn't. So
So many things right there. A, what happens when you assume? And
mhm.
then B, I do tell my risk management and insurance students, even though we are calling this quote an endorsement, end of quote, endorsements don't mean that we always add something back. An endorsement can be an exclusion. An exclusion is always going to be an exclusion, except if you have one of those weird exceptions to the exclusions. We won't even
Yeah,
get into those.
right, right.
You know, because lawyers have written these contracts, guys. That's
Yeah,
basically what
yeah,
it boils down to.
yeah.
There you go. Yeah.
And
So
I believe there are exclusions also, and I can't think of any off the top of my head, but I know I've seen them where they're somewhat conditional on certain circumstances. In other words, this exclusion applies if A, B, or C. Um,
I
I
have
bring it
seen,
up only because it's relevant to the fact that you really have to read these things and understand them.
yeah, I have seen that exact thing when it comes to roofing. Like
Mhm.
we only pay ACV unless you have repaired your roof or replaced your roof within the past 5 years, or there is no roof coverage at all unless you have repaired your roof. And usually in those instances, it is a conditional exclusion. So what the adjuster will need to do is ask for the receipts of that repair, and hopefully the insured would have already sent that to their agent to have that conditional exclusion removed. At least I would have. But then again, as we were just talking about, I'm a sophisticated insurance consumer as opposed
Well,
to, an unsophisticated one. I
yeah,
even put my pinky up with my
yes,
T. So let's talk about contracts, because we usually see contracts. And we're going to kind of move away from like the insurance policy aspect, which we just talked about there. But I want to talk about contracts in the general liability aspect of it,
okay,
because that's usually where we see it. And a lot of times we'll see it in the commercial side of it. And when you sign a contract, or when an insured signs a contract, they will often assume liability for something or someone. And of course, again, in my risk management class, I'll say that this is kind of like a non-insurance transfer of liability. And that means that there's no policy for that particular thing, but it's like that hold harmless agreement or whatever. Can you tell us a little bit about a hold harmless agreement and what it is?
sure. Sure. I think it'd be somewhat important though to understand the real function of a contract is that it's a written agreement. It can be verbal, but most of the ones we see are written, and it just means that both parties agree to all of these stipulations that they're going to either do or not do during a specific period. And that might mean that they're paying each other a certain sum of money, or that they are going to build something, or that they're going to tear something down, or that they're going to manage something. And everybody agrees that they're going to do it under the scope of this contract. And if one of the parties violates one of the terms of that contract, that's a breach. And that happens a lot in my world, because we see these agreements, and when somebody doesn't uphold their end of the deal, it can have an effect both on insurance coverage and who pays for what, whose insurance carrier pays for what. Um, anyway, so that's a quick overview of how all of these contracts live in an insurance claim. And the hold harmless part of it, I kind of see a hold harmless and a defense and indemnity kind of in the same vein.
Mhm.
What it means is that when I have to give a concrete example, I guess.
Sure.
When you've got a lease agreement with a tenant, the tenant agrees to hold the landlord harmless, and the tenant has a guest there, and the guest trips and falls on the stairs or in slippery conditions or whatever. The hold harmless obligates that tenant to protect the interests of the landlord if there's a lawsuit. Now, it doesn't mean that if the landlord was at fault, that the tenant is obligated necessarily to pick that up. You have to look at the circumstances of the incident. So, boy, I'm going to get into the weeds on this.
You are, but it's cool. I'm gonna help you out because
Okay.
we know that the hold harmless then means that basically the tenant will like kind of pick up the defense for
Yeah.
the insured or the insured landlord if the guest slips and falls on the stairs. But of course, it does depend if, let's say, our insured landlord didn't put ice melt down on the stairs. And, it's not been snowing or whatever. We're not going to get into, all of those kind of things, but he should have done it. He didn't do it. He had more than enough time to do it. So obviously it's his fault. This is when our tenant would not have to hold uh, or defend our insured landlord, correct? Yeah.
So
Oh, okay. Never mind.
here's
Let's get
here's where
let's get settled in, guys.
here's where it gets fun.
Let's
So I think to demonstrate this, my example has to have some very clear and concise theories of liability,
Okay.
so that we can really draw a line between when one picks up or the other picks up.
Okay.
So in one scenario, I'm going to have, we're going to use the banana peel. All
Right.
right. The banana peel is always a good analogy, or in discussions of slip and fall cases, the banana peel is the kind of the iconic thing that we all think about.
Hmm.
So let's say we've got a tenant, which is a grocery store. That's a bad example. Let's say this tenant is a barber shop. Okay.
Okay.
In the barber shop, he is cutting hair. He's eating a banana. He throws it on his floor. Customer comes in, steps on that banana, slips on the floor, and gets hurt.
Hmm.
The injured party files a lawsuit against the owner of the building and the barber. The owner of the building says, I have a hold harmless agreement. You have to defend and indemnify me. In that case,
Mr. Barber.
absolutely. The
Mhm.
Mr. Barber has to defend and indemnify the landlord. That's very, very simple. So, and that's the purpose of the hold harmless and defense and indemnity language. That's why it's in there. Ideally, there would be also an additional insurance requirement so that the barber would have the landlord as additional insured on his policy. That makes it pretty cut and dry.
Hmm.
The barber's policy would pick up that defense and indemnity. They would answer on behalf of both the landlord and the tenant and work on settling the case. All right, that's example number one. Example number two is Mr. Jones owns the building. He is the landlord. The barber is in there cutting hair. Mr. Jones comes to the place, drops a banana peel in his own parking lot of that rented space, and drives away. And a customer slips on that one. Now, that one's going to be a little different because, um, is the barber obligated to defend and indemnify the landlord in that scenario? I don't think so.
I wouldn't either.
The the landlord's lawyer might, or their insurance company might argue that, but the circumstances dictate that that's probably not the case. So those are two ridiculous examples that hopefully demonstrate a little bit of the way my mind works on these types of claims and how these agreements work together. Does that help to understand the hold
Oh, yeah.
harmless agreement?
Oh,
Okay.
yeah, yeah, yeah. And you mentioned, this leads to a good point, and I have always found this very, very difficult to understand personally, is how the additional insured status is determined. Uh, uh, And besides, I guess if it's not in listed, if these people are not listed in the policy, um, how do we know who's an additional insured? What do we do?
That's a fun issue also.
Oh,
Some
yay.
additional insured endorsements are different than others. Sometimes they will have a requirement that there's a written contract requiring the additional insured status. If you have one of those and you don't have a written contract, then whatever additional insured status you thought you promised to someone else, they don't actually get. Those are tough. Um, and sometimes an insurance certificate is issued that actually says that that person or that entity is additional insured. Or sometimes it won't say that. It'll just say that they're a certificate holder and they'll assume that they're on the policy.
Mhm.
It can get complicated.
Yeah.
We can do insurance certificates another time.
Yeah, because I have my own theory. I get up on my soapbox.
Oh
Imagine,
boy.
imagine that. I mean, me going on a rant about
Well,
something. I
I could
just like it's
imagine.
it's
I could
it's
see that.
unheard of. It's crazy. So, I was actually reading an article. Uh, what's his name? Randy Manilow. If y'all don't get his coverage opinions. He's an attorney, insurance coverage attorney. If y'all don't get his opinions, I do recommend that you get that, and we'll put his notes, his links down in the show notes. But I was just reading his newsletter, and there was a verdict that came out, and I don't remember where it was. But there was a verdict that came out where basically the court was saying if you do not, as the insurer, notify every additional insured in the policy that there's a coverage question, that you've canceled the policy. This accident or this issue happened to be about canceling the policy. Uh, Even if the additional insureds do not live together, if you as the carrier do not send out these notices to every single person, then they are not adequately informed and they may indeed have coverage. Do you have any comment on that? I'm springing that on you.
Yeah. So this sounds like a scenario where you've got like on a homeowner's policy where you've got two individual persons who are not necessarily related.
It was actually a car accident in
Okay.
which the parents had bought the daughter a car because or co-signed on the car or something to that effect because she didn't have enough credit for it. And I think the car was titled in both of their names, but she had the parents had the insurance. She was an additional insurance, and she was the one driving it. She lived somewhere else because I mean, she's over 26, wasn't like a teenager, basically,
Yeah.
wasn't at college. Some of those things. So the carrier only notified the parents at their one house and didn't notify the daughter. The daughter was involved in an accident. There was death involved. Yeah, I think the passenger died. And, a lawsuit had arose from that because the policy had been canceled due to non-payment of premium.
Okay. And they did not notify the additional insured.
They did not notify the daughter, who was the one driving the car.
Okay. Whew.
Yeah.
Well, auto policies have a different burden to them because there's a legal requirement to have them, and have your
Yeah.
car registered. And I'm not familiar enough with the cancellation requirements in even my own state, let
Yeah.
alone the state where you're talking about, to be able to comment on whether or not that was proper or improper.
Right.
But in my world over here with the general liability claims, is if a policy gets canceled, I don't know that there is an obligation to notify additional insureds if it's canceled mid, term for non-payment. I almost think if they're issued a certificate, they will get notified.
Hmm. I would then urge our adjusters listening to maybe talk to coverage counsel in their state, because I know that there's also kerfuffles about not notifying additional insureds, additional named insureds when there's coverage questions. Like they don't get copies of the reservation of rights letters or the non-waivers or whatever. So they're bebopping along thinking, like let's take Mr. Landlord, Mr. Jones landlord or whatever. If we as the adjuster sent a reservation of rights letter to the barber saying, hey, you may not have coverage because this is an intentional act, or I don't know, whatever.
Mhm.
So therefore we may not accept actually liability and then coverage or whatever. I have no idea. You know what I mean?
Mhm.
I'm making this up as we go along.
It doesn't
So
show.
yeah, no kidding. Which one is what we pretty much always do. Anywho, if we just sent that reservation of rights letter to the barber and the landlord, Mr. Jones, thinks that he's still being indemnified, if we pull the defense, I mean, he could be stuck holding the bag. So I
That's
would,
interesting. And I wonder what the obligations are on a claim where you've got multiple additional insureds and none of them are involved in the incident at hand, whether or not they need to be notified.
well, like I said, I've read just enough to make me dangerous. And my advice would be notify everybody.
Yeah, I mean,
Everybody.
it's just a few more words on a piece of paper,
And a
and
couple of more
send
stamps,
and
basically.
some postage. Yeah.
Yeah, and actually, uh, according to Randy in this newsletter, the defenses, the insurer's argument was, you have no idea how burdensome that would be for us to notify every single additional insured, every single additional named insured, every time we cancel a policy and then reinforce it and or reinstate it and blah blah blah. Um, so well, boom, there you go. And the court was like, yeah, don't care. It's a postage
Yeah,
stamp.
yeah, I
So
don't think that's a valid, I mean, you're accepting premium for that additional insured. So that comes with all of the
are you
baggage.
though? Are
Uh,
you? I mean, I don't think, okay, so now we're really off in the weeds.
I don't think additional insured endorsements are offered for free. Um,
But who's paying for that? The named insured.
yeah.
So then wouldn't it be the named insured's duty to, I mean, just to play the
Uh,
devil's advocate?
yeah, I don't think there's any obligation under the policy to do that, but
Yeah.
there would be, there is an obligation under the insurance law to inform a policyholder when something's being canceled. And the question is, does that obligation extend to the additional insured? I don't know.
I don't know.
We're so somebody who works in the underwriting department would be a better resource for that question
Yeah, and
than
that's
you
why I
or I
say,
think.
yeah, call coverage counsel.
But however, but we do have situations where there's no coverage on a claim,
Hmm,
and we notify everybody in those scenarios for sure. We CC everybody,
right.
unless they're not a party to the claim. I don't. My instinct would be to not notify additional insureds who are not part of the claim.
I don't know. Okay, so I mean, we are talking about what the consequences are of failing to meet the insurance requirements outlined in the contract, don't you think?
Huh? How'd we get there?
So we are talking about what are the consequences if the insured doesn't meet the requirements outlined in the contract. Because we've been talking about what happens if we, as the carrier, don't meet the requirements. Like if we
in
notify
terms of
everybody and don't notify everybody.
notification.
Yeah,
Okay, so yeah, the consequence of the carrier side, if they fail to do something, they might have to provide coverage where they normally wouldn't.
right.
That would be uh, their so to say punishment, I guess. Um, on
I don't
when you
think we
flip
want to use that word.
when you flip things and say that the policyholder did not comply with any a term or terms of the policy, then they don't get any coverage. So
Right.
if it's a property policy, they don't get their roof replaced. If it's a liability policy, they don't get a defense or indemnity for that claim against them. So that's the consequence of not complying with a material portion of the policy. It has to be a section that relates to the claim. Um, for example, if they've got an alarm endorsement, meaning
Mm,
that they have to have sprinklers and alarms and all that stuff in a commercial space, and they have a slip and fall claim, and they're in violation of that endorsement, it doesn't matter. You can't disclaim coverage for the slip and fall,
mm.
even though they may be in violation of a policy term. It's not material to that claim. So there has to be some link between the exclusion or the violation of the of whatever condition. There has to be a link between that and the incident.
So let me ask you this, because this is another thing that has always confused me in CGL claims. As much as I love working CGL claims, I do find the contract aspect of it to be somewhat confusing when there is this external contract, like landlord tenant kind of deal. How does
Like
that
our banana peel example.
exactly, so I guess we've kind of seen how that whole harmless aspect, but how does the entire thing, because the policy does actually mention like a railroad contract. And I'm like, who uses railroads anymore?
That's a sidetrack agreement.
Yeah, except that,
Yeah.
I mean, I do. We go to Chicago via the railroad,
Oh
Amtrak.
yeah.
Mhm.
Yeah.
Yeah.
Yeah, sidetrack agreements are funny because a lot of people say, well, it was a sidetrack. It was kind of on the side. It was a side deal. No, that's not what it is.
In New Yorker
Sidetrack.
accents. It's a sidetrack deal. You know what I'm saying?
So anyway, the where were we? You were asking
We were
about
doing our New York accents, and I do one really badly. Except when I go, "Hey, you doing?
how you
You
doing?
doing?"
Um,
This is gonna make a great cut for,
I know,
advertisements.
I know. You're gonna make me say a bad word again. So
Ah,
in the context of external agreements, the types that we look at are lease agreements, construction contracts, property management agreements. We've seen the agreements that DoorDash people have to sign. There's all kinds of agreement. There's agreements for beauticians, massage therapists have agreements that they use to work in certain spaces.
mhm,
So there's all manner of contracts and agreements out there. And as an adjuster, you're really looking for some core components of it. And one of them is the hold harmless and indemnity agreement or section of that agreement. The other might be subrogation or an anti-subrogation clause. Another might be maintenance.
mm,
So in our banana peel example earlier, if there is a requirement that the tenant um, keep everything clean all the time, including the parking lot where the landlord dropped his banana peel, well,
mhm,
that might change the dynamic of that scenario a little bit, because now we know that the barber has promised to keep the place spotless, including the outside parking lot. And he failed to do that on that day because there was a banana peel.
right.
Um, so, and then you can argue about notice and all these things, but but those provisions about maintaining the property, whether it's repairing damaged items like staircases and things like that, or simply shoveling and salting for winter conditions, or picking up banana peels,
Yeah.
trash.
You know,
All of those things will change the dynamic.
I have had lots of property damage claims where the tenant will turn in, claim to the building, water leaking, roof leaking, whatever, hail damage to the roof or whatever. And they're a tenant and and unfortunately do not have building coverage. And they're turning this claim in because they know that they are supposed to maintain the building, pursuant to their contract, keep the upkeep and maintenance and all this kind of stuff, but they don't have the insurance for it. And that has led to some awkward conversations when you're talking to the insured and go, yeah, you didn't buy building coverage on,
Right.
all you've got is contents. Um,
Yeah. So,
what you really need is kind of like a renter's policy, but not the HO4. But
yeah. So on a BOP or commercial
mm,
property policy, um, they'll have a limit for business personal property, or BPP.
mhm,
And a segment of that relates to betterments and improvements they make within their rented space.
mhm,
So within, let's say, a store, they rent the store, and when they first move in, there's a finished floor, drywall with paint, doors, trim, ceiling, heating, lighting, all that stuff. They come in, they install their own cabinets and shelving and chairs and tables and some permanently attached fixtures that are become part of the building. Most lease agreements will have some provision that addresses those betterments and improvements. And usually they'll say something along the lines of, once you attach them to the building, it becomes the landlord's property,
mhm.
which sounds crazy, but that's pretty much the way they're all written. But those commercial policies address that by giving coverage for those betterments improvements under the business personal property within the limit. So,
Right. But they don't cover like the outside roof.
right,
If
that's
there's a
the
hail,
landlord.
yeah, if there's
Yeah,
a hail damage or whatever, and those are the claims that I've had to, you know, handle.
yeah, yeah.
Is when the barber, for example, he's in a standalone building, for example, and he rents the entire building, but he's responsible for the entire building, upkeep,
Mm.
maintenance, everything.
So like a
And
triple net
yeah,
policy
yeah,
or
yeah, exactly.
lease.
Lease. And then, hailstorm comes through, damages the roof. And if the insured is only told the agent and the agent didn't ask the right questions, but the insured only tells the agent, yeah, I rent this space. And the agent doesn't say, well, is there a contract? Are you responsible for the building? It's upkeep, da da da. Da. And all they get is business personal property, BPP. They have no property coverage.
Right. Yeah, if
You know,
any part of that building was there before they got there, that won't be covered under the betterments and improvements
mm-mm.
section.
No,
Um,
no, it won't.
so it's important as a tenant to understand the lease you're getting yourself into, because if you are required to maintain that stuff and provide coverage for the building, you got to do that.
Yeah, yeah. So this would speak to, of course, the concept of indemnification and
Mhm.
how it works with insurance contracts or with contracts in insurance claims.
Yep. And we talked about hold harmless. The indemnification, defense and indemnification is kind of part of that. Um, and there was actually another segment. So we talked about defense and indemnity.
Yes.
We
Hold,
talked
which
about
is kind of like the hold
subrogation,
harmless with additional insureds.
additional insured requirement.
Uh-huh.
Yes, that could
Yeah.
be part of the maintenance and repair segment of the contract would be
Mm-hmm.
something that we would look at.
Mm-hmm. Yeah. Um,
And
what about what
there's
we briefly mentioned, and I do want to go back to it, is like subrogation.
anti
Or
sub waiver of subrogation.
yeah. and I wanted to go back to it,
That's a
because
really interesting topic, actually, because waiver of subrogation can be a provision in a contract or a lease or whatever. And what it means is that um, you agree not to go back after the other party for damages when a loss occurs. And if you have that in your contract, you might want to make sure that you also have a waiver of subrogation endorsement on your insurance policy, because that makes your insurance company also promise that they won't go after that other party.
so can you
Uh,
give us an example with our barber to help us out?
mhm. That's interesting. Can I give you an example with the barber?
The one that I think of with the
Oh,
waiver.
yeah.
Oh, okay, go ahead. Go ahead.
Okay,
Tell
I
me.
got it.
Tell me.
So if the lease agreement has a waiver of subrogation, and I'm going to make this waiver favorable to the tenant,
Sure.
just for example purposes. And the tenant, the barber, lights a candle or something and burns the building down. The landlord presumably will have coverage under his own policy. That waiver of subrogation will prevent any claims against the barber for that damage. How's that?
Yeah, no, that's very, very similar to what I was going to say, because the one that I know of, and I think it's a law that kind of came out of, or a regulation or verdict or whatever that came out of Oklahoma, was it involves apartment tenants. And if the apartment tenant does something to like burn down the building or whatever, the landlord can't go back against the tenant, because presumably the tenant would be an additional insured, because their rent would help pay for the landlord's insurance premium. And so under this theory, the tenant is, an additional insured, and you can't sue or subrogate against yourself. And
Hmm,
that is Oklahoma's theory, and that's what they're sticking to. And
interesting.
yeah, so I don't think they necessarily call it a waiver of subrogation so
Right,
much,
right.
but I mean, this was the thing when we were talking about what is a waiver of subrogation earlier. Yeah, I was like, this is the way that I perceive it to
Yeah,
be.
yeah. Interesting.
Yeah.
So that's part of the common law there then.
Yeah. Yeah. Yeah.
Huh.
And I know we've used it even in Arkansas, because we're like, it's just not even gonna, there are better hills to die on, I
Yeah,
guess.
yeah,
You know. Um, we mentioned though, most of our contracts are written, and
yeah.
I would always encourage everybody to get a contract that is written.
Mm.
But what happens if, my word is my bond, I'm going to shake your hand, and we're going to go on after we've said, Bill, you do this, I'm going to do this, and blah, blah, blah. What happens with a verbal contract?
Well, then you have to set out to really get into the details about what that verbal contract said and what everybody agreed to. So we need to get party A in a room and party B in a room, and we need to talk to them and ask them all these questions about what they agreed to. And if they say the same thing, you probably have an agreement. But if they don't, then you've got to see which one is more believable, and you got to kind of apply your reasonable person standards to that and see which one you think, which whether or not that agreement actually did exist, and if it did, how does it affect the claim at hand?
I think that's mostly the problem with the verbal contracts, is that we all remember them, a month later or whatever. But if if we continue to go on 2 or 3 years later, we don't necessarily remember what all the rules are. And that's how the problems necessarily start, I think.
I could see a scenario where you've got, you know, a verbal contract and something bad happens, and the conditions of that verbal contract would be detrimental to one party and beneficial to the other, and everybody's memory fades. But in an example where their memory is clear and they're both, everybody's in agreement, but they're only in agreement because they know that insurance is there to protect everybody. You know, that's another thing to think about, and what the people's motivations are. And you know, is there some kind of you know, silent agreement between those guys to conspire to make up this verb? You know, people are really honest mostly. So
Of course, of course, of course they are. I mean, we're not saying that
mostly.
they're mostly they are. But anyway,
I
what
have another
else?
thing to talk about with respect to construction contracts.
Yes, construction. This is when you see a lot of contracts. Yes.
Yeah, yeah,
Yeah.
piles of them.
Ugh.
And
Bricks and bricks of them.
yeah, so
Uh-huh.
reams. So we have labor law 240 subsection 1 here, which is falling worker, falling object statute. And that holds a building and owner and the general contractor strictly liable when someone falls from a height or something from a height falls on a person and injures them. And it's a, you know, it's a pretty imposing statute because strict liability is a tough one, and some of these accidents on construction sites are very serious. When people fall from, you know, a 2 or 3 story building, that's bad news.
Mhm.
So in response to that, the contract evolution here in New York has traditionally been that the building owner is doing everything they can to push off liability to the general contractor for those types of claims.
Yeah.
Now, I don't think, I may have seen a contract where they specifically reference labor law 240 within the contract itself,
Mm.
but most of them, what I just see is a kind of a standard boilerplate defense and indemnity, additional insured requirement. And they really try and lock down the insurance certificates. So it says this person or this entity is an additional insured for, you know, any and all claims on the above caption policy. Those and when those agreements are fuzzy, it gets very complicated really quick. Now, not only does the owner try and shove off responsibility to the GC, but the GC also does the same thing to their subcontractors.
Mhm.
And those subcontractors are often made to put the owner, so it's this cascading effect.
Mhm.
One of the ironic things about that is, so you got a building owner, you got a GC, and then a subcontractor. Subcontractors there, let's say it's a roofing contractor, and one of their employees falls off the roof. That employee is eligible for workers' compensation benefits from their employer, the roofer. They can't sue the roofer because the sole remedy is workers' compensation when you're an employee.
Mm.
But under labor law 240, they can sue the GC and the building owner.
Really?
Sure.
Wow.
Under labor law 240, because that statute makes those two entities responsible for state workers' safety,
Right.
specifically from height related incidents. So it's their responsibility to make sure that the roofers are tied off, that they've got fall protection of all kinds, and that they have to make the job safe from those hazards.
Right.
So that worker can now sue the GC and the owner. So they do. The owner points to the GC and says, you have to defend and indemnify me. And the
Mhm.
GC points to the roofer and says, you have to defend it. And so now the roofing company winds up settling the claim for their injured worker because they're protecting the GC and the owner.
Despite workers' comp.
Yeah, that
Wow.
happens a lot. Yeah.
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 That is very, very interesting. And I wonder, and I don't know if you know the answer or not. And again, I would like basically encourage our adjusters to contact counsel and get the answer to this, because I don't necessarily know the answer. If we are an additional insured, I think I would not only want that certificate of coverage because it really is just a snapshot in time, but if I'm an additional insured, I think I would want a copy of that policy because
Yeah,
I don't,
that's good advice to, if you are ever issued a certificate, and it sounds burdensome to do this, but you almost have to get a copy of the policy.
because we don't necessarily know what endorsements, because they won't list necessarily all the endorsements on that certificate.
Right.
And there could be, for example, um, Bill Wilson talks about this, where he has seen roofers get a policy that have a roofing endorsement or a roofing exclusion on
Exclusion,
them.
yeah.
So
Seen it,
basically,
been
there
there,
is
done that.
no coverage
Yeah.
for this, and he has bought illusory insurance.
Yeah.
And so he is not protected. It will have to come out of his own pocket. And a
Yeah.
lot of these things you got to remember too is that these subcontractors are like mom and pop stores. These are people who don't necessarily have, and they are relying on insurance to help them out,
Yeah.
um, in
Yeah.
these
It could
cases.
ruin a family business,
Mhm.
or an individual,
Yeah.
if you're an individual person and you own then I've got claims like this too, where you're an individual person and you own a commercial building and you hire a roofer and that roofer falls off. Now you're subject to section 240 subsection 1 of the labor law because it's a commercial building, and you're strictly liable for that.
So adjusters would
So
need to be looking at the policy too to make sure that there's not a, I don't know, roofing exclusion for their insured because
yeah,
they're a building owner,
yeah,
because that would be a huge coverage issue in and of itself.
yeah.
Another contract that we're
And those
dealing with.
additional insured endorsements, like I said earlier, they're all different. One is a blanket additional insured, and sometimes that's packaged in with a policy. They'll give you all these bells and whistles, and that would be one of them, where you get this. Uh, it's called a blanket additional insured endorsement, and it covers anybody that you promise to add as additional insured. But I do think it requires a contract. And as long as you've got that, then they're on. Some are more restrictive, and they're just by specific name or at a specific location, or even specific dates. Especially a construction project, they'll from September 1st to December 31st. That's the coverage period. That's for that additional insured, and that's it. Um, yeah, it's a fun world.
It is a fun world. What else do we need to know about with contracts?
With contracts
Yeah.
in general.
Well,
Oh, when you're reviewing a contract as an adjuster, don't let them just send you one page.
oh God, yeah. You
A
got to
lot of
see the.
times they'll just say, "Oh, you just want to see the defense and indemnity part. Here it is, page 4."
Mhm.
Nah, I want to see the whole thing because there might be other provisions that are important.
It's just like your insurance policy. You got
Right.
to read the whole thing. And sometimes they are very like 8-point font, single spaced,
Yeah.
54 pages.
Faxed 15 times.
Yeah. Yeah.
Um, the other thing you want to make sure is that it's executed. If there are
Mm,
no signatures or dates, you don't have a contract. You've got a piece of paper. You have a potential contract. You don't have
right.
an executed contract.
Yeah.
Um,
That's a good point, because a lot of times we as adjusters may just get the copy, not the executed copy. Same thing with the additional insured. What I would say is make sure that you're getting the certified copy of the policy so you know you're getting the whole thing. Yeah.
right.
So that's a
In
good point.
cases with no signatures, I've had all the parties stipulate that, yeah, we meant to sign it. We agree in principle, and the contract is held to be valid in those cases.
Mhm.
But in other times, not so much. I've had a subcontractor show me a contract that they were given after an incident took place, and they were asked to sign it and date it prior to the incident, and they refused.
Good for them.
Yes.
Mhm.
So, that's something to watch for too, especially in the labor law example I just gave, because that's an incredible shift of burden from the owner and GC to the smaller subcontractor. And if they didn't agree to those terms, that's a problem. And their
So
insurance company should not be the one on board for that if they didn't actually agree to do that. I mean, they may have agreed to other provisions of that contract, to use a certain type of roofing material, to do it by a certain date, to do it for a certain price. That doesn't necessarily mean that they also agreed to add everybody as additional insured on their policy and to defend and indemnify all of those entities. So those are interesting disputes.
I would say for the investigative purposes, not only as the adjusters are getting a copy of that contract, the executed contract, the full copy of the contract, but also we're taking recorded statements of everybody, including our insured. Did you sign this? Did you know what you were signing? Like, did you have the capacity to do it? Were you bullied into it?
Mm-hmm,
Yeah, or
mm-hmm.
whatever. That's all part of the contract aspect of it.
Right, right. And oftentimes I'll ask those questions in a statement and they won't know.
Ooh,
Do you have defense indemnity in your contract? I don't know. I'm not sure. The lawyer drew it up. I never read it.
yeah, I just signed it.
Yeah,
Yeah.
I just
Well,
signed it.
would you then have conflicting terms then in insurance policies and the contracts and things of that nature? I don't know.
Can you have conflicting terms in well, sure, the anti-subrogation, waiver of subrogation, I said earlier,
Yeah.
would be one where you have it in a contract or a lease, but you don't have an endorsement on your policy. I think that just because you agreed to do that by contract doesn't mean that your insurance company can't subrogate. Um,
See, I would disagree because your insurance company is stepping in the shoes of you.
okay, but
So
it's not agreeing to contracts that you've.
no, it's not. I don't know. Well, isn't it though? I mean, isn't it if we've got the barber who is taking care of the roof? Because if you think about it, okay, the barber who is taking care of the roof of the building that he is leasing, he
Is he
has no,
he's insuring the building?
yes, he's insuring the building because his contract says he has to. His
Okay,
his rental contract says he has to take care of the building, right?
okay.
He has no insurable interest in that building. So why are we as the insurance company paying for
I,
it? Go ahead.
I think he does have insurable interest in the building because he's a tenant there.
I don't.
Well, without the building, I think he does have. So if he actually, they wouldn't allow him to buy a policy if he didn't have insurable interest.
Yeah, because they gave him the wrong policy that he just has the BPP. Because he said, "Hey, I'm renting this building," and his agent didn't ask, Are you supposed to be taking care of the
If it
building?"
was okay, so if it was purchased with the pretense that he was the deeded owner of the property, then that is a misappropriation of that insurance coverage, and that's not
Right? That would be
valid.
fraud.
Yeah.
I'm not talking about that. I'm
Okay.
talking about my example where I have had insureds who rent a building from Mr. Jones,
Yeah.
right? Mr. Jones' rental agreement with my insured says you must take care of the building. You have all the maintenance of the building. You have to fix anything. You are completely responsible for the building in addition to paying me rent.
Okay.
And our barber, for example, goes to Mrs. Retail Agent to buy insurance. And the barber says, "Hey, I'm, renting this space here. And of course, I want all of my stuff covered, right?
So it
All of my
gets
barber's
PPP only.
chairs, all of that kind of stuff, the scissors, all of that kind of fun stuff."
Yep.
And she goes, "Great, no problem. And they issue a commercial property policy, but there's only contents listed. So it's only business personal property, BPP, right? Um, he files a claim, Barbara files a claim. I, as the adjuster, go, hey, you don't have building insurance, so I can't pay anything. Full
Right.
stop. Boom,
Yep.
right there. Okay, so let's back it up just a little bit. Barbara goes to Miss Insurance Agent and says, hey, I, am renting this space. And she's like, fine, let's do building because your policy, because you got to take care of the building. That's what your rental agreement says. And then let's cover your stuff, which is contents. So while I pay, because the rental contract says that my insured will take care of that roof when there's a hail damage, and it's a covered loss,
Hmm.
I would pay that claim because the contract says so, even though the insured does not have insurable interest in that building.
So you're saying they wrote building coverage
Yes,
on that policy,
yes.
even though he doesn't own the
He
building.
doesn't own the building, and I
Yeah,
would honor that claim.
I think you probably would have to.
Yes, I think so too. But that's what I'm talking about with, I mean, I guess that's kind of conflicting terms because the concept of insurance is you have to have insurable interest in it, at least for your property damage. And the insured, the barber, does not have insurable interest. He doesn't own that building.
Right.
So there's no insurable interest in that building. So why would we, as the insurance company, pay for the roof damage that for the roof that he clearly doesn't own?
Right.
Except for the fact that his rental agreement says he has to.
Yeah. Yeah. I'm not sure that's conflicting terms as much as it is a mistaken approach to covering the building.
Yeah. Okay.
Um,
Mm,
but and the only other real conflicting thing that I can think of right now is the waiver of subrogation.
okay. All right.
But I bet you there's more.
Oh, I bet there is. But
And we've
we
only
only
been
have so much time.
we've only been talking for an hour and 15 minutes now.
Eh,
So
no, it's okay. We'll edit some of this out, I'm sure.
yeah,
Yeah, like more of our rambles.
yeah,
So our key points are basically read the entire insurance policy,
yep,
read the entire contract that the insured gives you,
yep.
make sure that it's signed, dated, all of that kind of stuff.
Hmm. Oh, and one other thing we probably should have said. In fact, we should say it now and then edit it and put it at the beginning.
Okay.
We are not attorneys, and this is not legal advice.
Yes. I would think that would be self-evident when we keep going. Yeah, you need to talk to an attorney. Yeah,
Uh,
so
After about 10 words out of our mouths, they should understand we're not attorneys, I think.
yeah, yeah. Yeah, we're just making this stuff up as we go along, but we sound
Yeah.
really good when we're doing it.
Yeah.
Yeah. Yeah. So I would encourage everybody to apply these concepts to your investigation. Making sure that you ask the right questions, that you're looking at the right things. Because we've learned about that waiver of subrogation. That's new. And then making sure that the policy has it. Because Bill and I were kind of like, yeah, don't know if we would, if the insurance policy didn't have it, but the contract, the insured does have it. Does the carrier have the right to go against the at-fault party, even though the insured doesn't? I say no. Bill says, "Mm,
And there could, each carrier may have a different way to handle these things. And
exactly.
if you're a newer adjuster and you're still getting your feet wet reading policies
Mm,
and you're having a problem understanding the lease agreement or contract or whatever, and how it's applicable, reach out to the people in your organization that can help you to understand that.
yeah,
And there's no shame in not. I mean, I ask questions all the time for things that I don't understand. It's part of this business. It's what we do is ask questions.
yeah. And I would actually say, and I should have said this to my students yesterday, because I had this whole room where they just were silent. And I finally got them to talk to me, and they're like, we didn't understand the question. We didn't know what the answer was. And I said, so you just sat there? And I mean, if you don't know, it's perfectly okay. And I should have said this to my students, it's perfectly okay not to know the answer. I mean,
Mm.
heck, I've been doing it for like 25 years. You've been a claims adjuster for what? About the same amount of time? But
Oh,
you're younger than I am, so maybe 15.
96.
Wow. So
I'm younger than you.
no, I'm kidding. Um, so you know, the thing I like about being an adjuster is you learn something new every single day.
Yeah.
Every single day you
And
learn something.
I've sat across professionals, attorneys, claims professionals, executives with years and years of experience, men and women that you would think that know everything because they're just so intelligent.
Mhm.
And you know what they do when they don't understand something that it seems fairly simple to someone else? They
What?
ask a question. They say, I don't understand what that means. Can you clarify it for me?
Yeah.
And, really smart people do that
Yes.
because they don't know all the answers all the time either. Uh,
Mhm.
we can't be specialists in everything. The smartest
Amazingly.
people in the world will have questions from time to time.
Absolutely. So again, our word of advice, our parting word of advice is ask questions for our newer adjusters, even our senior adjusters. Our next podcast is going to be March 28th. We are going to be discussing something which I think is really, really important. It's water claims in regards to storm, surge, tides, rainwater, flood, backups, overflows, all of that kind of fun jazz, because a lot of times things get denied when they probably shouldn't be denied. Or things get covered when they shouldn't be covered. So we'll see. Hurricane season, of course, is coming up in June. So there you go.
Timely, yes. And
Yes.
the fall season, or sorry, the spring season around here is typically full of, sump pump problems and
Mm,
backups
exactly.
and things like that because of the snow. But this year we have no snow,
Yeah. We're
no
getting a
snow.
lot of rain though, here in Kansas. So same thing, a lot of rain. It's going to saturate the soil. And then is your sump pump working? All of that kind of stuff.
Yeah, yeah,
Yeah.
fun. Well, I
Yeah.
can't wait for that one.
Okay. Sounds good.
All right.
Well, we'll see you later, Bill.
All right. Take care. Bye bye.
Bye.
Thanks for joining us on the Art of Adjusting podcast, where we talk about life as an insurance adjuster.
If you enjoyed this podcast or this episode, please give us 5 stars and a review. It does help the algorithm pick us up.
Hit that subscribe button real quick and tell all of your adjuster friends to check this out as well. For independent adjusting services, go to www.auten.claims. And for anyone interested in working as an independent liability adjuster, go to the Contact Us tab to join our roster.
In the meantime, you can contact me at theartofadjusting.com for consulting and training purposes.